I'm Drew Stevenson, and this is a lecture for my administrative law class about the case Massachusetts versus EPA. And this was a big case with kind of two distinct parts, so I'm breaking it into two separate videos. In fact, my casebook has part of it in one part of the casebook and the other part in another part of the casebook. And so this part is about agency refusal to regulate and judicial review for that. The other part of this case is about standing, and I'm going to discuss that in a separate video. Now, as a way of introduction to this case, again, this section of the case is in the availability of judicial review section of my casebook. A lot of administrative law casebooks are going to put this right after Heckler v. Cheney, which said that, where the Supreme Court had said that there's no judicial review for agency inaction, for the agency just not enforcing a statute or not enforcing a regulation as much as you want. This, however, was a more politically charged case because it's about global warming or climate change, where there's clear partisan positions that are sort of opposite extremes on the issue. And the EPA's refusal to regulate greenhouse gas emissions from automobiles. And so in this case, the court is going to draw a distinction between enforcement actions, which was Heckler v. Cheney, and distinguish that and say this is different because here the agency is actually refusing to promulgate regulations, and that creates a different issue, and we have to evaluate that under its statute. So let's look at what happened here. So we start with a group of 19 states. And by the way, due disclosure, I was working at the Attorney General's office in one of these states when this case was sort of being cooked up, and may have worked on a very small part, like one memo about this. But a consortium of 19 states, with Massachusetts as the lead, through their state attorneys general, sued to compel the EPA to regulate carbon dioxide from cars as air pollution under the Clean Air Act, which the EPA had not been doing. Now, again, remember, part of this case is about whether these states even had standing to sue. And I discussed that issue, the standing issue, in a separate video. The EPA refused, even though they got a formal petition to regulate, saying that they didn't have statutory authority to regulate carbon dioxide emissions. And even if they had authority, it wouldn't do it. They weren't going to. Please note, there was also an issue in this case that I'm not going to talk about that much in this video, where they were saying this is about car emissions, and that's would really create sort of a turf war with the Department of Transportation, and which the court sort of dismisses that and says you would be able to work it out with them. So the majority here focuses on the word judgment. I'm kind of giving you the spoiler about how the case ends here, and rules against the EPA. The enabling statute says that the EPA director in his or her judgment shall promulgate standards for air pollution. And here's a quote, sort of a zinger quote from the majority opinion. Put another way, the use of the word judgment is not a roving license to ignore the statutory text. It's a direction to exercise direction within defined statutory limits. Now, it's kind of a part of what's astonishing about this opinion is how the majority and dissent disagree about what the word judgment means in the statute. And the majority sees something mandatory when it's paired with the word shall, when it says the agency shall exercise judgment, that means the agency shall basically undertake the prolonged process of deliberation and rulemaking. The dissent is going to say, no, judgment inherently implies discretion for the agency. Now, remember that we have this case, Heckler v. Cheney, which is still good law, that says basically we're not going to have judicial review, except maybe in extreme cases, for agencies who don't bring enforcement actions. So in other words, you're mad that an agency isn't enforcing the law enough, that's a really hard case to bring under Heckler. So the court finds four main differences between this case, rulemaking and enforcement. In other words, in one case, we're talking about non-enforcement of a statute, and here we're talking about a refusal to regulate. And so refusals to regulate are, one, less frequent than refusals to enforce existing regulations. This is an important point. I just want to explain each of these very quickly. Agencies have to make enforcement decisions every day, right? They don't have infinite resources or infinite staff or prosecutors or inspectors or enforcement agents. And so kind of every day of the week, they are having to put off some enforcement or going after a particular violator. On the other hand, the possibility of promulgating a regulation comes up less frequently. So this wouldn't be the court having to micromanage an agency on a day-to-day basis. This is something that might come up once a year, every couple of years, something like that. They say that also refusals to regulate are more apt to involve legal as opposed to factual analysis, which makes it more suitable for judicial review. In other words, when an agency isn't promulgating regulations, this is very likely to relate to a question of its enabling statute and whether the enabling statute gives it discretion about whether to regulate or says it has to promulgate regulations. Some enabling statutes are very explicit that an agency has to promulgate standards by a certain date and things like that. And so that's a legal question, and appellate courts are good at that. They're good at statutory interpretation and then asking if the agency is doing what they were supposed to under their statute. Whereas a decision not to go after a particular violator of a regulation is very fact intensive. Maybe the agency doesn't have evidence. Maybe they're waiting to catch a conspiracy of violators. Maybe they need to develop the case more. Maybe they're not sure if the person violated and then stopped. The third difference is that this is subject to special formalities. In other words, a decision about whether to go after bring an enforcement action against a particular violator of a statute or regulation could just be a conversation in the office at the agency. Should we go after this guy or not? Whereas a decision not to regulate or to regulate has a lot more formality involved. If you really want to get technical under the APA, the decisions to regulate, of course, are even informal ones will be subject to notice and comment rulemaking, whereas a decision about whether to go after a violator is more like an agency adjudication, or maybe even less than that. Also, under the APA, responses to petitions for rulemaking include some procedural rights for petitioners, whereas there's no counterpart procedures or rights for refusals to regulate, people who want the agency to bring in more enforcement actions. And the court here points to APA section 555E. Prompt notice shall be given of the denial in whole or in part of a written application, petition, or other request of an interested person made in connection with an agency proceeding, except in affirming a prior denial. When the denial is self-explanatory, the notice shall be accompanied by a brief statement of the grounds for denial. And so under 553E, you can actually petition for rulemaking, which the plaintiffs here did. And then that requires that the agency give a written explanation why. And then this says if you have made that petition under the other section 553E, 555E of the APA says that they basically have to have a brief statement of the grounds for the denial. And the court here says, so that kind of gets us into court and creates a question for the judges to look at whether the agency gave a brief statement that's grounds for denial and a decent explanation of it. So again, remember, in this part of the case, not the standing part, but in the part about the agency refusal to regulate, the EPA had two main arguments. And the first was that they didn't have statutory authorization under their enabling statute to regulate carbon dioxide. And the court addresses that first. And the agency specifically was talking about carbon dioxide in the upper atmosphere is not an air pollutant regulable under the Clean Air Act. And this was a pretty sophisticated answer. This wasn't just saying we don't believe in climate change. They were saying that climate change is caused by carbon dioxide accumulation in the upper atmosphere, not the part of the air that people are breathing. And they were saying that the Clean Air Act is, when it talks about air pollutant, is talking about the air on the surface that that humans breathe. And so that was their claim, somewhat plausible, I think, but not convincing, that the agency lacked legal authority to issue a rule on car emissions. And the majority disagreed, saying that they thought the text does give the EPA authority here. Please note that the dissenting opinion, which Justice Scalia wrote, says that the text is ambiguous enough to entitle the EPA at least to Chevron deference on this point, and that the agency's reading of the act was reasonable. And I think reasonable minds can differ on whether the agency is being reasonable here, and that's part of our problem with Chevron is it's not always clear when Chevron applies. And this is an ironic sort of case where the majority thinks that the statute is clear, and it's usually Justice Scalia that's the one saying the statute is clear, and therefore there's no Chevron deference. All the justices here, the majority and the dissent, did agree on the point that when the EPA makes determinations about potential harm under the Clean Air Act, prudential factors like cost are supposed to play no role. And that should remind you of the case we studied earlier in the course, Whitman versus American Trucking Association. Now, where the majority and dissent part company, though, is whether the agency's decision not to make a determination or a judgment, I put it in quotes because that's a statutory term, is A, reviewable, and B, reasonable, even if it's not based on factors directly related to public health and welfare. The court moves on then to the EPA's position that regulating greenhouse gas would be imprudent or premature right now. And carbon dioxide specifically. I should clarify for my students, the EPA does regulate some other greenhouse gases like carbon monoxide, but this case is all about CO2 or carbon dioxide. The justices all agreed that if carbon dioxide counts as an air pollutant, then the EPA would be obligated to regulate once it made a judgment that the specific pollutant may reasonably be anticipated to endanger public health or welfare. So no one thinks that the EPA can just refuse to regulate things that are indisputably air pollutants, but they think that it's debatable whether carbon dioxide is air pollution. Now, remember, the carbon dioxide, it's not really hurt. No one is alleging that the carbon dioxide injures people when they breathe it. The injury is that it affects global temperatures, right? And therefore causes a rise in sea levels and extreme weather patterns and so forth. The majority concludes that the EPA's act of non-judgment, of refusing to give a judgment, is reviewable, but they actually stop short of commanding them to prohibit greenhouse gas carbon dioxide or make such a judgment. They just say that the process of making a judgment is mandatory unless the agency can provide some reasonable explanation as to why it cannot or will not exercise its discretion to determine whether greenhouse gases contribute to climate change. In other words, if the agency could come forward and say that there's no way for us to answer this question scientifically, which they weren't really asserting, that would be a different matter. The majority reads the Clean Air Act as allowing only one factor to guide the agency's discretion in proceeding or refusing to proceed to make a public health determination called for in a rulemaking petition. And namely, that's the scientific practicability of arriving at the necessary determination. And you may remember from some of our other cases that there are questions that the safety agencies like the EPA and OSHA and the FDA simply can't answer. We don't have scientific evidence to be sure about safe levels or what the best threshold amount is for certain, let's say, toxins or pollutants or things like that. So there could be a case where the agency says we don't have enough scientific knowledge to answer this question yet, and that's why we are unable to make an intelligent regulation or a science evidence-based regulation, but that's not what they were alleging here. They were saying that it's not clear enough that the situation is urgent or that their regulation would make any difference and so forth. Here's a review question to see if you've been paying attention to this video. If an agency's enabling statute says that it shall make a judgment about a specific regulatory question and set the rules to protect human health, can the agency simply decline to regulate on this subject? Yes or no? Hopefully, if you've read the case and have watched this video, you know the answer. And if not, you should probably review this. Okay, that concludes our part 1 lecture about Massachusetts versus EPA.